Hey everyone, welcome back. So today we're tackling something that, let's be honest, completely terrifies a lot of people, but absolutely needs to be demystified. We're talking about foreclosure. You know, that total sinking feeling you get when you open the mail? Well, our whole mission in this explainer is to take what feels like a totally chaotic nightmare and break it down into a clear, manageable, step-by-step sequence. Because once you actually see the structure behind it, that fear, it starts to fade and real understanding takes over. Look at this quote: foreclosure is a timeline and procedure, not a conspiracy theory. We have got to address all that internet mythology right out of the gate. I mean, you've probably seen those online gurus claiming you can just magically defeat a foreclosure with secret sovereign catchphrases or by treating the whole system like some kind of private paperwork ritual. Well, spoiler alert, you can't. Foreclosure is a really strict legal process. It gets solved by actually playing by the rules of procedure, definitely not by guessing. Okay, let's dive into this. Here's our roadmap for the explainer. First, the foreclosure reality check. Then, why timelines beat arguments. Default and early notices. Judicial versus non-judicial paths. And finally, what happens after the sale. So, Section 1, the foreclosure reality check. Now, you might be wondering, why do most people lose their foreclosure disputes before they even set foot in a courtroom? I want you to really think about this for a second. Put on your investigator hat. It is not because the banks are some invincible force, and honestly, it's usually not because the borrower didn't have a valid argument somewhere buried in the paperwork. It's actually a massive structural failure on the part of the person trying to fight the foreclosure. And here is the exact reason why. They literally do not understand the stage they're in. Look, a borrower who is just 30 days late on a payment is in a vastly different time zone than a borrower who just got served with a massive lawsuit. If you don't know where you are on the map, you're inevitably going to use the wrong tools, you'll completely blow past critical deadlines, and you'll end up begging for remedies that expired months ago. This is where panic takes over and tragic mistakes happen. I'm talking about people responding to a simple, basic default notice by trying to file a full-blown lawsuit. Or, even crazier, they treat an actual formal legal complaint like it's just junk mail and completely ignore it. Seriously, no way. They'll demand proof from a servicer while a pending complaint is literally sitting right there on their desk. Or maybe they try to fight a post-sale situation as if the property hasn't already been auctioned off. All of this stems from relying on terrible internet advice and just completely failing to grasp their own case's procedural posture. Moving right along to Section 2, timeline first, argument second. Listen, these core rules, they are your absolute lifeline. Every single foreclosure has documents. Every document has a date. Every date has legal significance. And every step has rules. Notice the repetition there? Timing completely controls your remedy. You just cannot build some brilliant cinematic legal argument about a missing signature or a fraudulent transfer if you don't even know what deadline you're facing tomorrow. Mapping the timeline absolutely must, and I mean always, must come first. So to bring some actual order to all this chaos, we've got to stop treating the situation like it's some unsolvable mystery. You need to ask these exact diagnostic questions. What happened? When did it happen? Who did it? And, most importantly, what document proves it? If you can answer these 4 questions, you instantly replace all that panic with hard data. All right, Section 3, default and early notices. Let's walk through a typical early timeline so you can see how this actually unfolds. Month 1, usually a missed payment or maybe an escrow shortage. Basically, some alleged breach of the contract. By month 2, federal rules actually require the servicer to make early contact for loss mitigation. Then, around month 3, boom, a formal notice of default or a breach letter shows up. This is crucial because it tells you exactly what has to be cured. And by month 4, if things are still uncured, the lender hits the acceleration button, meaning they declare the entire full balance due immediately. You simply cannot fight a default until you've identified exactly what breach they're alleging and what specific notice they sent to prove it. Now, I want you to burn this number into your brain: 120. Under rules from the Consumer Financial Protection Bureau, a mortgage servicer generally cannot make that very first legal filing required to start the actual foreclosure process until a borrower is more than 120 days delinquent. Now, sure, there are a few rare exceptions, but generally speaking, this 120-day rule is a massive, highly protective buffer. It's designed specifically to give you time for loss mitigation. So think about it. If a foreclosure magically starts on day 60, you instantly know a rule might have been broken. But again, you'd only know that if you were tracking your dates. Next up, Section 4, judicial versus non-judicial foreclosure. Okay, let's contrast these two procedural forks in the road nice and cleanly. A judicial foreclosure is a full-blown court case. The lender is the plaintiff, they file a formal complaint, you get served by a process server, you have a strict deadline to file an answer, and ultimately a judge orders the sale. Now, a non-judicial foreclosure, on the flip side, bypasses a full lawsuit entirely. It relies on what's called a power of sale clause hidden in your deed of trust. But listen to me very closely here. Non-judicial absolutely does not mean lawless. It is still a highly strict, heavily statute-driven procedure involving incredibly precise mailing, posting, and publication requirements. Now, what's really interesting about this next part is the specific actor involved in the non-judicial route. You have to pay very close attention here. You'll often see documents appointing a substitute trustee. This is the authorized actor who manages all the paperwork, issues the notice of default, and actually conducts the auction. Verifying that they were legally and properly appointed before they took any action, that is a massive part of checking your timeline. Which brings us to Section 5, the sale and beyond. So, what happens after the gavel falls? First, we have to talk about the concept of redemption. In some states, defaulting borrowers actually have a statutory right of redemption. This means they can literally recover the property even after it's been sold at auction simply by paying the sale price plus some specific legally required amounts within a certain time frame. Why does this matter to you? Well, because foreclosure isn't just about stopping a sale. It's also about protecting your hard-earned equity and exercising every single one of your remaining rights. Then, of course, we have the final financial consequences, surplus versus deficiency. If the property happens to sell for more than what is owed, including all those legally recoverable charges, well, that creates a surplus. And guess what? The borrower might actually be entitled to those extra funds. But if it sells for less than the debt, it creates a deficiency. And depending on your state's anti-deficiency laws, the lender might actually try to come after the borrower for that remaining balance. As you can guess, both of these outcomes are incredibly sensitive to, you guessed it, deadlines and procedure. Okay, let's synthesize everything from this explainer into a rapid-fire, empowering checklist. Step 1, build the timeline. Step 2, identify the stage. Step 3, find the notices. And Step 4, check the dates. Honestly, if you follow this checklist, you replace all that paralyzing panic with absolute procedural control. It's a total game changer. And that leaves us with this final, absolutely vital question. Based on the exact dates and documents that you've mapped out, what remedy is actually still available to you? Please do not fall for internet memes. Look at the actual law. Your timeline is ticking right now. So, are you mapping it or are you just guessing? Thanks so much for learning with us today, and we will see you in the next explainer.